infinite grace and power. So I'll welcome Sushma and Banu to lead us into prayer.
Within the whirlwind, you say the words be still. You are my fortress. My trust in you is still. Within the whirlwind, you say the words be still. You are my fortress. My trust in you is still. All of my past, you are by my side. You stand right in front of my eyes. Even in the future, you'll be mine. I am on the strong. You are my all. On the sky, taken from Book of Proverbs, chapter 4, verses 6 to 10. Do not forsake wisdom, and she will protect you. Love her, and she will watch over you. Wisdom is supreme, therefore love wisdom. Though it costs all you have, yet understand. This is the word. The Father, nothing to do, all you can do, will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not to temptation, but deliver us from evil. For thine is the kingdom, and the power of, and the glory forever and ever.
Thank you, Sushma and Banu. Intellectual property nurtures and encourages innovation and creativity, thereby contributing towards cultural and economic development of the society. This IP can be a very effective tool in achieving the vision of the Atmanirbhar Bharat. So now I invite our dear principal sister, Dr. Sister Mercy, to just speak few words during this regarding this webinar.
Good morning to one and all. On behalf of the host college, CHSD St. Teresa's College for Women, Eluru, as its principal and the IIC president, I deem it a great privilege to accord the warmest welcome to the resource person, Mr.Shailendra Singh, NIPAM officer, Ministry of Commerce and Industry, and to each and every person who is attending this workshop on intellectual property rights and intellectual property management for startup. In February 2019, our Honorable Prime Minister Narendra Modi ji digitally launched from Jammu and Kashmir about 120 career hubs in various colleges all over the world, all over the country, I'm sorry. I feel proud to say that our college was one of it. Since then, all our activities were refocused on providing job opportunities to the students. From the time we joined the IIC fraternity, there was no looking back. Our college, which got the title College of Excellence from UGC, opened its doors for innovation and entrepreneurship. Today, our college has the credit of 11 patents and 22 copyrights. Today's workshop is a significant step in making our college an innovation campus. Though our college is non-technical in nature, we want to create an innovation culture that will assist the unevenly or poorly prepared students to succeed. Our IIC Center is trying to foster a culture of innovation through creation, sharing, and testing of ideas. I thank our NISP and IIC team of staff and ambassadors for their active leadership. I also appreciate Dr. M. Padmaja, the convener of this workshop. I pray for God's blessings for the grand success of this workshop, which could be judged by the type of fruits it will cause to yield in future. Thank you, and once again, welcome to each and every one of you for this workshop.
Thank you, sister. Thank you for your warm wishes. IP awareness is essential to ensure that the intellectual capital being generated in the country gets due recognition and protection, so that IP creators can enjoy benefits emanating therefrom. In view of this vision, the Office of CGPDM has formulated this mission, that is the National Intellectual Property Awareness Mission (NIPAM), which will be undertaken under the Government of India's initiative Azadi Ke Amrit Mahotsav. It was launched on 8/12/2021 by Shri Anurag Jain, Secretary of DPIIT, and the Pan-India Ambitious Mission aims to provide awareness on intellectual property and its rights to 1 million students. That is, it is doing under two categories, that is children from 8th to 12th class and students of higher education, to ignite and inspire the students from all the colleges and universities to innovate and protect their creations. And also during this launch, it was emphasized that this IP should be a tool to move forward, and the IP holder should become a job giver rather than a job seeker. So with the main aim of this IP awareness, we are very fortunate to have Shri Shailendra Singh ji from, he's an examiner of patents and design. He's an NIPAM officer under Ministry of Commerce and Industry and Department of Promotion of Industry and Internal Trade, Patent Office, Delhi. We are very fortunate to have you, sir. And now I request sir to take over the session. Welcome, sir.
Yes, very good morning to everyone, and very good morning to M. Padmaja ma'am and Mercy ma'am for giving me this opportunity and thankful for such a warm welcome. First of all, introducing myself, I am Shailendra from Ministry of Commerce and Industry, and it is my privilege and honor that your institute has given me this opportunity to share my learnings from patent office with all of you. Today we are having this seminar on webinar on IPR, intellectual property rights. So basically, why we are all gathered together, the reason is that we need to understand the economic structure of this country. Now, if you see the years back, the economic structure of the country and the government's motive was quite different from the present scenario. Earlier, most of the companies and ventures are controlled by the government. So it's kind of socialist type of economic structure. So if you see the changes that is taking place in the present scenario, now more and more people have started having their own businesses, more people have started having their own startups and companies. So it's like a capitalistic type of environment in this country. And if we talk about the numbers, now if you can see the present data that India is third largest ecosystem of the startups. So here we can see that it's a huge number if you compare all over the world, that there's so many people in this country who are interested in starting their own businesses, their own companies, and they want to work as an entrepreneur, and they want to give jobs to the people. So it is very much important for us to understand this intellectual property rights if you want to start your business. Even for academician also, it's a very useful tool. So if I talk about another thing is that if you compare the countries like China or USA, and if you compare it with the India, India is also having so many companies and startups and everything. But if you see the intellectual property rights, patents, especially, you will see that China is filing around to 1.5 crores of patents in a year. And if you see the US, then US is filing around 65 lakhs of patents in a year. And is seeing the Indian country now, India is filing only 50 to 60 thousands of patents in a year. So there's a huge gap between these countries, these capitalistic countries, and in between and India. So it is a very much required that we need to aware the people to the education system, to the university institute, that people should understand the value of this IPR. So going forward, I first like to introduce you with the IPR term. Basically, what is an intellectual property right? Intellectual property right is basically a right which is an intangible right. What is an intangible right? Intangible right means the right which we cannot see. Like we have so many physical rights, like we have land, we have cars, we have buildings, but we are never aware about this particular intangible right, that is IPR. There are so many different registrations that we have in the IPR, like we have patents, we have trademark, we have copyrights, we have others as well. And if you see the power of these intellectual property rights, you will find out it is very much useful in the present scenario. If you have created any if you have created any type of written data, or maybe any invention you have done, or maybe anything which is very novel, or maybe genuine or real, then it can be a very economic generating for you for the years, even for so many years. You can see so many examples in India, like if I share you with some of the very known examples, like we have Chetan Bhagat. Now Chetan Bhagat is a very known writer of India. Now that particular person, while he was writing any books in the past, he has never thought that he could become so much popular in India, and he can get so much of income out of it. Now he has just written some books. Now after getting the popularity, he has the people have also made the movie on his books. So you can see that your creativity can be beneficial for you even after 10, 20, 30, maybe n numbers of years we can't even imagine, and it can also give you so much of money that we have never thought about. So it's a very useful and important thing. Before going further, I like to first, if I ask each and every one of you that how many different IPRs you can see around yourself, that if I ask you that what are the different IPRs you see in your room, you will start counting the things like this TV can be a IPR, means maybe related to patents, or this fan, or maybe this. So you start telling me things which are mostly electronics, or maybe something which is basically physical things, most of the things. But if I give you the actual thing, that everything around you is a part of IPR, whether it is uh, any electronic equipment, whether it's table, chair, or clothes, everything is a part of IPR. The thing is that because someone has used his intellectual, his brain to create those things, the only thing is that some intellectual property, some creations of the people or man's are intellectual property rights, because they are noble, and they are very much genuine, or they have registered these things. And some are where copied things. So you cannot say that this is not an intellectual property. It is an intellectual property, but it is not registered. So I like to first introduce you all with a small video clip to just start the thing, just to give you a little bit of idea that everything around you is a part of intellectual property rights. Just whenever I share, just please tell me that whether you will it's visible to you or not, because sometimes due to technical glitches, some part of the video or maybe the presentation will not be visible. So just tell me if there is any interruption. So is the video visible to you?
It's visible, sir.
Okay.
ఆయన వీడియో కాదు, ఆయన వీడియో షేర్ చేస్తున్నారు.
వీడియోనే.
Just look into the video clip, just to this video just to give you an idea that everything around you, where when you see all around in your home, around the places you go, you will see so many things that are the part of intellectual property rights. Now here it is written, this painting in a house can be a geographical indication. So there are so many things in our house, like paintings or clothes, that can be a part of this geographical indication. So I think this video would have given you a little bit of idea that everything around us is a part of intellectual property rights. The only thing is that we are not aware about those things. Now we'll start our presentation. Now, is the presentation slides visible to you? Is the presentation
Yes, sir.
slides visible?
Yes, sir. Visible, sir.
Okay. Okay. So there are so many intellectual property rights that we have in our system for the registration purpose. That these are the patents, design, trademark, geographical indication, copyright, and semiconductor integrated circuit layout design. So what is our need, that if we are starting any business or if we are working in any field, then what is our first duty? We need to recognize a different intellectual property right that is related to our creativity. So if I am a writer, then I should understand that I will have to register this particular written material under copyright thing. Or if I want to start any business, then I should understand the importance of trademark, that I should have the trademark, the name for my company or maybe my business. Or if I am developing any technology, then it should be a patent. I should take the patent so that I should stop others from using my technology. So in this way, I need to recognize the different properties that are related, and how I have to identify these things. So in this particular slide, you will see a very simple example of this laptop. Now, in this particular laptop, now before introducing the laptop into the market, now what has Apple company has done? Now Apple has introduced in the this particular laptop into the market, and they have registered it under so many different categories. Like they have registered the technology under the patent, they have registered the outer case or the laptop under design, and they have registered the trademark, this Apple science under trademark. And user manual of the laptop is a copyrighted thing, and the IC circuit that is used in the laptop is a SICL design. So you can see that before introducing a simple laptop that we see in the market, there are five different intellectual property that are linked with it, and they have registered these. They have identified the different intellectual property rights, and they have registered them with the department. Now, what is the importance and significance of this intellectual property rights? Now, the importance that it will protect your intellectual property, it will exclude others from using it or making it or manufacturing it or getting any economical benefits, and will also helpful for you to utilize and commercialize or and earn more creativity. Now, what are the different type of people who can go for the intellectual property rights registration? So it's very obvious that this for a businessman it's a very useful tool, because it will help them commercialize, it will help them create the brand value, it will help them earn and invest more and more. But if you talk about the for the common person, it is also very beneficial. So for a person who is related to academics, so it can be a thing for pride for them. So if let us assume that if I am a student of any institute, and if I have some written material which is a copyrighted thing, and if I belongs to BA or maybe BCom or any of the fields of arts, and if I show this particular thing, and if I write this thing in my CV that I have two books written, I have some copyrights of two books. So they will the interview the person who is taking my interview will definitely say see the and distinguish myself between 100 or 200 people who have come for the interview, and he will see or he will see that and say that that particular person is very nice in writing, and he has copyrights for the different books, so he is very much beneficial to our company or our corporate world. So in this way also it's very useful. And for if I talk about for the professors or maybe for the faculties also, it's very useful thing, because if let us assume that if you are having so many patents or maybe research papers or maybe copyrights or maybe other different things in the intellectual property, right, it is very beneficial for them for the academic growth as well, because the better CV, better intellectual things you have, like if you see any renowned person who is from maybe a vice chancellor or maybe any very high post in the academics, then you will see and find out there are so many research papers or patents or other things are being filed or being under his name. So so it's a pride, and the people will think that that particular person is very intellectually high. So in this way also it's very beneficial for the common people also. Now, thing that we have in our system is patents. Now, first thing that I would like to introduce you about with the patent is that patent is basically a sovereign or a state right. What does it mean? Sovereign or state right means if you are having the patent in India, then it will only be only you will have the exclusive right only in India. You cannot stop anyone from US or UK or any other country from making or manufacturing or selling that product. The reason is that because you have not taken the patent of that technology or maybe that product in any other country. So if you believe that you need to have if you want to have the control over in multiple countries, then what you have to do, you have to file the patent in multiple countries. And if you believe that you will have the business only in India, then you should have the patents only in India. So first thing is that it's a first sovereign or a state right. Second thing is that it is for a limited period of time. And what is the limited period? The limited period is 20 years. So if you are filing anything today, then it will be protected for a period of 20 years. Means right from today up to the upcoming 20 years, it will be protected. And after that, your invention or your product or whatever you have filed for a patent and you have the patent for that thing, it will be in the common public domain, and they anybody or whoever who wants to use it or may manufacture it or may utilize it for their purpose for the manufacturing or any other means, they can use it after the 20 years. So this is particularly the different inventions of the past that we have, like we have Alva Edison's phonograph, we have Graham Bell's telephone, we have aeroplane of the Wright brothers, and so many others. Now you will see and find out that, and if I ask some of the people, then they will say that there is a very less scope to create any new fundamental in physics or any other technical field, because most of the fundamentals and researches are already been done by the people in the past. But it's not like that, because you need not to create anything out of the box to get a patent. If you see so many examples of the present, like we have the example of telephone. So earlier the telephone was a wired phone. Now the things have changed and someone has used his intellect and converted that wired phone into the what cordless phone. And after the cordless phone we have the mobile phone. In the mobile phones also the technology is changing day by day. Earlier it was a keypad phones. Now after that we have the touch phones. Now in touch phones after that we have single sim, now dual sim. In dual sim also the Apple has recently introduced a new technology, eSIM phones. So there are so many changes that is taking place day by day in the known technologies also. So what is basically a invention or innovation? Basically, invention or innovation is a any upgradation in the prior art. Means prior art means any previous technology, or maybe any technology that is or any product that you are uh, uh, giving to solve any social problem through the device or maybe through the technology. So it is an innovation, and these innovations can be filed for the patent. Now you will see this particular examples of patent. So many examples are here. Now see this particular child's cap. Now what is this basically a cap? Now it's a cap which is solving a very beautiful that is solving a very nice problem in a very nice way. Now this now usually when a child's take bath, now what happens? They their eye gets teary because of the soap or maybe any other chemical things that use to clean them. So to protect their face from getting wet, so what is this cap is protecting their face. So it's a type of product which is solving a problem of this wetting of the face, and these type of innovations can be filed for a patent. And it's a very useful product. You may be thinking that it's not useful in India because people are not very much interested in these products, but it's very much useful in many other countries. Now, this particular slide will give you a little bit of idea that these are the newspaper articles from different companies or maybe the government that Apple has filed for a patent, or Toyota has filed for a patent, or defense ministry has filed for a patent. So these particularly just to give you an idea that any of the company or even the government department, what they have to do, they have to file for a patent before launching their product into the market. The reason is that because they don't want companies or any other uh, uh, company or any people to copy their products to manufacture the same product using their technology which they have developed. So to protect that thing, what the companies do, they first file for a patent, and after that they introduce that particular product into the market. Now the patent application filing. So basically, maybe you have not filed anything in the past, or maybe you some of you maybe belongs to the education field, and maybe people around you have given you a thought that it's a very complex and it's a very tedious process of filing any patent. But it was a past in the last 4 or 5 years the things have changed a very drastic way, because everything is processing in a very fast and very simple and fast way, and you can get the patent in around 2 years maybe, or 1 year, depending upon the way you have filed the application. The process of the filing the patent is very simple, and the only thing is that you need to understand the basic process of filing of the patent. Now, if you see, there are almost 30 forms in the patent, but there are only 5 forms that is required for any person to understand the filing process of the patent. All other forms are correlated or maybe required if you want to do any changes in the patent filing, like afterward you want to do any modifications or maybe for any other purposes. So these 5 forms are required for any person who wants to file the patent. These forms are Form 1, Form 5, and Form 18. Now I like to introduce you all with all these forms and I try to explain the things related to these forms. Now the form 1 is the basic form which is required, in which you have to give us the details of the applications and the applicant and the inventor and the address and the other basic details. This is very much similar to any other forms or anything that you fill for the examination purpose or maybe for the any other government application. So it's a very simple and similar form. Now the second form is the form. Now form 2 is the form in which you have to describe your invention. Now for the description purpose, you have the two possibilities that either you have completed the invention or you have not completed.
120 దాకా ఉన్నారు.
So let us assume that you are working on any invention and you have not completed it yet. So you have not completed yet, and
120 ఉన్నారు
before
ma'am.
introducing the technology or before sharing that knowledge with any other person, uh, uh, what will happen if you share this information with any other person, maybe with your friend or maybe any other person? What will happen? They may understand the thing and they may file the patent before you're filing, or they may completely file the things because they know the things in a better way. So to solve that particular problem, what you can do, you can, before disclosing any technology with any unethical person or maybe a person you don't have trust. So before disclosing to the things to anyone, what you can do one thing, you can file form 1 and form 2 with the provisional specification. So in the provisional specification, what you have to do, you have to give the basic idea about your invention and all the basic other things. Now the government gives you 1 complete year to complete the invention. Now for the completion of the invention, you have 1 complete year. Now complete the invention and file the complete specification without before the completion of 1 year. Now form 1, form 2, you are now aware about it. Now we come to the form 3. Now form 3 is basically a form in which you have to give the description about the filing you have done in the foreign country. Means, let us assume you have filed any application in US and UK, and or if you have filed any application in India and you also want to file a similar application in US and UK, then you have to disclose this information to the office that in through the form 3 that I have filed a similar application in these two countries. So for that purpose we have this form 3. Now after that we have form 5. Now that is declaration as to inventorship. So while filing the form 2, I have told you that there is one way of filing the form 2, that is provisional specification. So at that point of time, if someone has not completed his invention yet, so there may be a need that you require the help of some other person. Maybe you took the help of 1, 2, or 3 persons, and they will only help you when you make them the co-inventor or give them the money. So let us assume they ask you to make them the co-inventor in your application. Now, so after the completion of the invention, now earlier it was just you, only one inventor, but after the completion, there are, let us assume there are 4 inventors. So now you have to disclose this information to the office that now after the completion of the invention, there are inventors in my application, and for that purpose, we have this form 5. So after filing 1, 2, 3, and 5, all these 4 forms, your application will be published in the Indian Gazette. So after this publication, you application will be published, and everyone, means whoever is wants to know, they will know that your application is published, and they will understand that this type of invention has been filed by XYZ person, or maybe companies can see that this particular invention or this particular product is being filed by this person. So it is beneficial for them for the in the process of getting the industrial things, means for the industrial feasibility also it is very much useful, this publication, and also to get the investors attraction. So let if so you if you have developed something very much useful to the society, and it is very much beneficial, then after the publication you will get so many people who will come to you and they will say that I would like to invest in your company. Or this publication will also be useful to you in a way that you can go to different companies, correlated companies, and you will show this paper that I have published this particular document, I have developed this product or technology, and if you like to invest you can invest on that, and I have the patent, I have filed for the patent for this. So this patent publications works in this way. So but the important thing to understand about the patent publication is that patent publication has no meaning in this IPR world. Means if someone says that I have 15 papers published in patent, means I have 15 patent publication, it means it doesn't mean that his patents are granted. It means only the publication. So publication and granting is a very different thing. Patent is only useful and beneficial when it is granted. Publication has no economical benefit, or maybe has no actual meaning in patents. So it is very much necessary to understand that patent grant is important. Patent publication is just a in between process. It doesn't make any change in this filing process. So after the four filing of the forms, the last form is the form 18. So for filing the form 18, that is request for examination, that is required if you want to get the patent granted. After the publication, if you thought that your product, and if you introduce this particular product with XYZ companies, means like, and you believe that it is not feasible to get the patent because it is not industrially useful, so what you can do, you can stop the process here, and you can you should not waste much more money. And if you believe that it is useful to you and you want to get the patent, then you can go for the request for the examination. So for filing the request for the examination, there is a period of 48 months to file this particular form. So after filing all these 5 forms, your application will go for the examination process, and we will give you the report after that. Now the fees for the patent filing. The fee for the patent filing is 1600 and 4000 for the natural person and the startup or a small entity or educational institute. So if your institute is filing anything, then what will be the fee? The 1600 and 4000 rupees. So the total fees is 5600. So if you don't belong to this particular category, that is, if you belong to any company or something like that, then the fees will be 8000 and 20,000 rupees respectively. What is natural person? Natural person means like persons like you, me, or maybe a group of 4, 5, 10, 100, XYZ number of people, they will be considered as a natural person. Now there are two modes of filing the patent application. One is the hard copy filing and second one is the e-filing. So for the hard copy filing, you need to file the application directly to the patent office, which is situated at 4 different locations. So it is at Kolkata, Chennai, Mumbai, and New Delhi. So for you, the geographical region is Chennai. So if you want to file any hard copy things, then you have to submit it in the Chennai office. Now e-filing mode, for the e-filing you have to file through this particular website, that is ipindia.gov.in. And for filing, after opening this particular website, this type of page will open. Now in this page, what you have to do, you have to sign up and give the username and other details, and this page will open you, where you will see all the different forms that I have told you. Now the expedited examination. So all the other things that I have told in the earlier slides was the basic way of filing the patent application. Now, some people have a thought that I want the patent, or we want the patent at the earliest, because it's very economically beneficial for my industry, and I want to know the actual thing, that whether it is a patentable thing or not. So for the expedited means, if you want to speed up all the process of the patent filing and granting and other things, you can go for the expedited examination. In the expedited thing, your application will get the priority, means it will get the priority above all other application being filed. So for the expedited examination, the eligibility criteria is there, that you need to be a startup or a small entity, or for you, because most of the people are female in this webinar. So I think it is very much beneficial for them, because if any of the applicant is a female, then you become eligible for the expedited examination. And other is like, if you are a department, a government department, then also you are eligible for the expedited examination. Now if you don't belong to any of the above given category, then this one, if you have chosen India as a ISA, IPA and the PCT, then you become eligible for the expedited examination. What is the meaning of this particular thing? I will explain you in the upcoming slide. So this is a particularly the criteria, that if you want to go for the expedited examination, you need to have these uh, particular requirements. Now the patent application processing. Now there are three different ways of filing any application, that is ordinary, convention and PCT. So that PCT is related to what, this the fourth point, this fifth point, India as a ISA, IP in the PCT. So I'll explain that thing in this slide. So ordinary way of filing is what I have told you in the previous slide, that form 1, form 2, form 3, form 5 and form 18. So whatever things that I have told you comes under this category of ordinary way of filing. Now the convention way of filing. Now the convention way of filing, the only difference between the ordinary and the convention way of filing is that if you have filed any application in any other country prior to India, so let us assume you have filed any application in US and UK, and you believe that you want to have the patent in India also, then what you have to do, you have to file the similar application within a period of 12 months. Means you are having 12 months of period, and you need to submit it within a 12 months of period from the date of filing in other countries. Means if you have filed the application in US today, then you have 12 months to file the similar application in India. Now other process and other forms are almost similar to the ordinary way of filing. So the ordinary conventions are almost similar. But in the ordinary and convention application, what you find out, that your application will be published, like let us assume that you have filed the application in 5 countries: US, UK, China, Japan and India. And after filing the application in different countries, what happens, that uh, you will get the report from the different countries, that 4 countries have rejected your patent. So the reasons may be because according to them the things are novel, inventive, or maybe the thing is not patentable. So that thing you will get to know at the end of the process. Why? Because you yourself don't know that whether the thing is patentable or not. But so it is very much a kind of loss of so much of money, because you don't know about the actual reality about your application. You will get to know the things at the end of the complete process, after filing the request for examination in different countries. So you will get to know this particular thing at the end of the process. So to get to know about the report of your patentability, means to understand that whether my technology or product is patentable or not, you can go for this PCT process. So what is this PCT? PCT is Patent Corporation Treaty of the WIPO, World Intellectual Property Organization. World Intellectual Property Organization is a particularly an organization which controls all the different IPRs in different countries, and all the countries are the members of it. And out of those members, some countries are the part of a part as a ISA, means International Search Authority. So out of these international search authorities, it is your wish, wherever you want to, which country you want to choose, you can choose by yourself. Means if I am an Indian, I have the full liberty to choose India or UK or US or China, any country as a ISA for this report, PCT report. Now, what happens in the PCT report? In the PCT report, if you submit any application through this PCT mode, your application will get you will get the report about the patentability, means whether the product is patentable or not. Means you will get to know that whether the things will be granted in the coming process or not. You will get the report on that in the starting. So in this particular PCT mode, if you choose India as a ISA, I have told you that you can choose out of the multiple countries, you can choose India or any other country, it's your wish. But if you choose India as a ISA, then you become eligible for the expedited examination. That is this thing. If you have choose India as a ISA IPA in PCT, you become eligible for the expedited examination. So the thing is that so if you don't belong to any of the categories, so if you are a company or if you are a man, then what you can do, if you want the expedited examination, you have to go through the PCT process and you have to choose India as a ISA. Now the screening and the classification, there are some in some application which are not patentable, means you will not get the patent for those applications, means or those inventions or technologies or maybe products. So those applications are atomic energy or defense related. So if any of the applications related to atomic energy, we will send this application to the atomic energy department, or if it is defense related, we will send it to the DRDO. So after getting the report from these two concerned departments, we will if they say that it's okay and you can go for the patents, then we will examine your application, as your application will not be examined and it will be abandoned. Now the examination process in the patents, talking about the examination process, first is the formal examination and the second is the technical examination. The formal examination is basically a simple thing that we will see all the different forms like form 1, 2, 3, 5, 18. So we will see and look that whether you have filed all the application forms with the right details and proper fees has been filed within a proper time domain. So these basic details we will check in the formal examination. Now the second is the technical examination. In the technical examination, your application, your invention will go through the three check system of our process, that is a novelty, inventive step and industrial applicability. So if all the things are okay in this particular process, then you will be we will send you a report, that is FER, first examination report. And in the first examination report, we will send you all the objections and other different things that you have not done correctly, and we will communicate that to you. So after sending this communication through this first examination report, you will have to reply the report within a period of 6 months. And after getting the reply from you, we will re-examine your report and we will see whether everything is okay or not, whether everything is complied or not. If everything is complied, you will be granted a patent. Else, what will happen? We will recheck and we will send you a hearing. Means we will ask you for a hearing. That will be technical discussion between the pending objection between the applicant and us, and we will see that whether everything is okay now. And if it is okay now, then you will get the patent granted. Else, it will be refused. Now there is a complete timeline of the patent, that is provisional to complete 12 months, request for examination 48 months, reply 6 months, form 3 6 months, form 5 1 month. So these are the different timeline that I've already explained to you in the previous slides. So that was all about the patents and patent filing and all the processes. Now other IPRs are little bit simpler, but it is very much important to understand these different other IPRs also. What are the reasons that are there, that they are required, and what is the importance of these other IPRs. So the second we have in the system is the designs. So I'll start the design with a simple example, that let us assume that I want to buy a car, and I give all of you some details that I want to buy a car which cost around 10 lakh of rupees, and I ask you that I like Maruti company cars, and I give you some other specification that I want to buy a car which costs around 10 lakh of rupees, and it should be from Maruti company, and it should have some 1500 cc engine, let us assume. So these specifications I have given you. Now there are some multiple options of the car that are available in the market. We have Ertiga, we have S Cross, we have Brezza, or we have XL6. So there are multiple options with these specifications. So if there are 100 or 200 or 300 people in this webinar, if I ask you this question, you will say that I'll buy S Cross, or you will say I will buy Brezza, or you will say I will buy Ertiga. So how you are judging your car? On the basis of designs only. So this outer look, the aesthetics of the commodity or the product is very much important. So whenever the technical features of any thing, or maybe whenever the features of any commodity or product become similar, or whenever the economical cost of the products become similar, we start judging the things on the basis of the designs. And sometimes designs are very much overpowering thing, that we only judge the things only on the basis of those aesthetics. We are not interested in the features and other thing. We only interested in these outer look of the particular product. So what is the industrial design? Industrial design is basically features of shape, configuration, pattern, ornament, compositions of lines, or any other thing which are solely judged by the eye. So if I give you that, if you see anything, the outer case of anything, maybe outer case of the mobile, or maybe the outer case of the laptop, or maybe whatever you are seeing around yourself, that can be registered under the industrial design. What is the term of design? Term of design is 10 years, and it can be extended up to 5 more years. So total term can be 15 years. Now the forms required for the filing of the design application. Now the design applications, the fees is 1000 rupees for the individual, startup and small entity, and for others the fees is 4000 rupees. Now what are the forms required? The form required is form 1, in which you have to give the basic details, the applicant full name, nationality, and other address and basic other things. Now you have to submit the 2 sets of representation of the illustrating various views of the articles. Means whatever you want to file for the design registration, you have to give the 2 sets of the copies of the different drawings. Now this is a sample sheet of the design registration thing. Now in this particular teapot that you are seeing here, now what you are asking in the design, that in the design you will get only the outer look, means the outer structure of this particular teapot. If there is any process or maybe any mechanism that is linked in that teapot, you cannot ask for that thing, or you cannot claim for that thing in this particular registration. For any process or for any mechanical thing, we have the patents. So you cannot claim any, by virtue of this registration, any mechanical or any other action by means of whatever, or in the respect of any mode or principle of the constructions of the articles. Second important thing about the design is that if you have filed anything for the design, and let us assume that if I put anything on it, like if I write S on it, then it doesn't make it another design subject. Means if I write NIPAM on this particular product, on this teapot, then you cannot say that it's a different design uh, thing, and I can go for the registration. No, it's a similar and same uh, product. Just writing anything, or just give putting any number, or writing any number or anything, or trademark or these things, this doesn't make it any other design product. So you cannot claim any no claim is made by virtue of this registration to any right to the exclusive use of the word, trademarks, or appearing in the registration. Now in the design also the same thing is that we will send you a FER report, and you have to reply it within a 6 months of time. And terms of the design, I have already told you that it is for a 10 years earlier initially, and if you still feel that you want to have the registration more years, then you can extend it up to 5 more years. Now the next that we have in our system, that IPR, is the trademark. Now many people have an idea that trademark is basically the name of the company and other things. So trademark is basically a very important aspect for any business or for any commercial thing or anything that is which is related to the commerce or economics. So if you want to expand your business, then the best way is to have the trademark, because for expanding your business you need to have a particular name through which the people should identify your commodity, your technology, or maybe your products that you are selling, or maybe any services that you are providing. So if I give you some examples, like let us assume that I am traveling to any highway in Andhra Pradesh, and because I don't belong to that particular location, I don't know which on the highway that where is a good restaurant means which restaurant is good or not. Means if there may be some very popular restaurants on the highway, but I don't know because I don't belong to that particular place. So at which place I will eat? I will definitely go to those places which are recognized or which are aware to me. Like I may be going to Udupi Wala, or maybe Haldiram, or maybe Bikaner Wala, like these, because these are very known brand names, or maybe Domino's, or maybe Pizza Hut, because I am assured about the quality and standards of these brands, but I don't know the quality of or the standards of any other local brands, or maybe unknown shops, or maybe restaurants. So this trademark is very much beneficial for the consumers, because it will help them identify the different sources or service providers. So what is a trademark? So trademark is basically any word, name, symbol, or devices, or any combination of them, which identifies and distinguishes the source of the goods or services from one traders from the others. So basically it is helpful for the consumer also, and it is helpful for the uh, service provider, or maybe manufacturer also. What are the different subject matters that we have in the this trademark? That is, these are trademarks, trade names, collective marks, certification marks, taglines, slogans, shapes, and sound marks. So we have so many examples. Like we have the examples of sound marks, like uh, whenever you open any laptop or any mobile after switching it off, what will happen? It's some kind of sound that comes from your laptop or maybe your mobile. So these sounds are the trade sounds of those companies. So these are particularly the identifications of the trademark, means how to identify that whether the product is a registered or trademark or not. Now for any product or any company that comes with this R written on it, means if let us assume that someone has registered this NIPAM word, and for the registration for the trademark, then if it is R written on this particular NIPAM, R is written on it, then I will definitely say that this particular NIPAM word is registered under the trademark. But if anything is under the process of registration, or if someone has filed or there is pending thing, then that particular word will come with the TM. So there are so many examples of the registered and the trade TM words. Like if I give you some examples, like all the beverage bottles that you will see, or maybe different brands like Adidas, or maybe Reebok, or XYZ, so many brands are there. You will see are written on that name. Or beverage bottles, like you have Bisleri, Coca-Cola, or Aquafina, or maybe Thumbs Up. So you will see are written on it. So the reason is that because they are the registered companies under the trademarks. Now TM, some of the example of the TMs, like you see Samsung, so many new products, like they have recently introduced one AC in the market, that is wind-free AC. Now in that wind-free term, you will see that wind-free, particular wind-free word comes with the TM word. Now this TM is written on that particular wind-free term, because that is under the process of registration. Now how what are the tenure of the trademark? Trademark is given for a period of 10 years. Means uh, If you want to file for a patent, then, for a trademark, it will be given for a period of 10 years. It can be extended up to indefinite period, but what you have to do, you have to refile the application, you have to renew the application within a completion of 10 years. And before the completion of each 10 years, you have to refile it again and again. Renew your app license. Now the next IPR that we have in the system is the copyrights. Now the copyrights is a basically a very is a right which is given to the proprietor and which is given to the people to stop the copying of their creativity, their written work, or maybe the audio work, or maybe the video work, or maybe any other art forms. So copyright is basically a right to not to copy. So what are the different subject matter that comes under the copyright is literary work, artistic work, dramatic work, musical work, sound recordings, and cinematographic films. So these are the different subject matters under which you can file for registration under the copyrights. Now the copyright thing is that the term of protection in the copyright is that it is for the different work, the term of protection is different. Means for the dramatic and for the published work or for the written literary work, the term of period is life of the author plus 60 years. For the cinematographic films and sound recording, the term of protection is 60 years from the date of publication. For the broadcasting production is 25 years from the date of broadcast, and for the performance right, it is 50 years. So for the different work, we have the different term of protection. Now, how to file this copyright? In the copyright, you have to just submit this form 14, and form along with this form, you have to just give your material, whatever the video, audio, or maybe the written material, you have to submit it. And after the scrutiny, you will get the report that whether it, and you will get the copyright. Now the examination fees, the fees is for the literacy, dramatic, and artistic fees work is 500 for the artistic, which is not used on goods and services. The fees is 2,000, sound recording 2,000, and cinematographic films is 5,000 rupees. Now the next that we have in our system is the SICL design. Means semiconductor integrated circuit layout design. So what is basically SICLD? SICLD basically is, if you see any of the electronic product, you will find out that all the product comes along with the particular type of electronic circuit, that is a combination of different ICs, or maybe different semiconductor devices, or maybe different things. So this particular layout, the combination of all these different combination of semiconductor things can be registered under the SICL design registration. The thing is that, because if you find out that, let us assume that let us assume that Samsung is making some mobile. Now if someone takes out the complete circuit layout of this Samsung mobile and they used it in any other company, in any other outer case, and if they so what will happen, the particular person will get the similar output as we will be getting in the Samsung mobile. So to stop this copying of the SICLD, means semiconductor integrated things, stop the copying of these circuits, we have to register the product under the SICL design registration. Term of protection for the SICL design is 10 years. Fees for the different work is different in the SICL designs. Now the last IPR that we have in our system is the geographical indications. So what is basically geographical indication? Geographical indication, basically any product, it may be a traditional knowledge related product, or maybe any art form, or maybe any painting, or maybe any commodity that we wear, or maybe any variables or edibles, means the things we are eating, or maybe any other thing which are related to any particular geography and being developed only at that particular place. Means that has some geographic essence, or maybe the people around that place have the traditional knowledge of developing that particular product or that art form. So to give them popularity, to give the people around that place of that geographic region to get the popularity and to get the better business, the government gives this geographical indication as a registration thing. So GI tag is basically given to any community or maybe any state or maybe any group of people or society. The reason is that because it cannot be filed by any individual. It should be filed by any community or any state or maybe any group of people. So what is a geographical indication? Geographical indication is an indication that identifies that product that have a specific geographic origin and possess qualities or a reputation that are due to that origin only. So you will find out so many examples of the geographical indication. Like we have, if I talk about from the south, we have a very popular example of silk, that is Kanjivaram silk sarees. So it's a geographical indications of that particular place. We have Darjeeling tea, we have Pali Hills tea, we have Madurai Mali, and we have Wayanad rice, and so many examples from the south. And if I talk about the other examples like Makrana marble or maybe Ratlani save, Darjeeling tea, or maybe edibles, like we have so many fruits and other things like Magi Pan and saffron from Kashmir and oranges from Nagpur, Kurg, and lychee from Bihar. So there are so many things and products that we have under the GI registration. Now, the summary of all the different IPRs that we have in our system, that is the patent is given for a period of 20 years, designed for a 10 plus 5 years. Trademark is for an indefinite period. We need to renew our registration within a completion of 10 years. GI for a period of indefinite period, similarly, same as trademark. And copyright is lifetime of the author plus 60 years for the for this published literary work and dramatic, artistic, and musical work. Who can apply for the different IPRs? Anyone can apply for the different IPR except in the case of geographical indications. The career opportunities in the IPR field now, in the government job, we have the examiner of patents and design, examiner of trademark, and GI examiner of copyright, patent agent. If in any other field, we have patent agent, patent attorney, trademark agent, SRF and JRF in patent facilitation centers, and we have patent litigation and other opportunities in private sectors. If I talk about the patent agents, the if anybody from belonging to the science field and if they have the law degree or if they qualify the patent agent examination, then they will become eligible for the patent attorney. As a patent attorney, they can work. And for the trademark, there is no requirement for the science background. But for the patents, they require science background. It can be anything. It can be BSc, it can be B Pharma, it can be BTech, any of the fields. But they needs to be, he or she needs to be a science background field person. Now that is the Rajiv Gandhi National Institute of Intellectual Property and Management that is situated in Nagpur. This is particularly a training institute where you can get multiple training sessions for the different things, like if you want to learn the drafting of the patents, copyright, any other trademarks and other things, you can directly contact this institute. There are multiple courses that are run by this particular institute, and you can also see the website, that is ipindia.gov.in, and you will see so many flashes that are being introduced by this RGN IPM Institute, and they you will see in the flashes that this particular course is run by the institute right now, and you can opt the courses as per the requirement. So this was all about the patent and patent filing and other different IPRs. So if anybody has any question, you can ask me directly related to IPR and patent or any other things.
Close it to me.
Sir, one question, sir.
Yes, please.
If any of our faculty are going for a patent from a college,
Yes.
and if it like for Atal ranking and all, they're asking it should reflect to the institute also, no, sir? So, should the patent filer be the college or can the individual staff can file, sir?
Basically it's up to you only. In some institute, they institute, if they are working under the institute, they sign some memoranda or some undertaking that if you are working in my institute, you have to file all the application under my name only. So it depends only on the individual and the institute's understanding. We don't have any part on it. It's up to you. If your institutes allow you, you as an individual, you can file the individually. Or if your institute say that your that institute name should come for under the patent as an applicant, then you have to go for that.
And also one more question, sir. If like 10 members are there in the team for the patent, so if suppose if I am a sixth member in that team, it will be counted for myself only, sir, or it will not reflect to the institute because it is filed by the person number one. He is from, suppose he is from an engineering college, and I am the
Yes.
sixth person in that patent, sir. So we can show it in our credits, sir.
Yes, yes. Actually, there is one form in the patents in which you have to just submit it, and you have to say that we want our name to be written on the patent application. That this particular patent is filed by this XYZ 10 people. Then all the 10
Yes.
people's name will be written
Mm.
on the patent
Okay.
paper. That these are filed. These particular is granted under these names. So you can
Okay,
get
sir.
that thing.
Okay, sir. Thank you, sir. Thank you.
Yes. Any other question, please?
Yes, Santosh, you can ask.
Yes. Good afternoon, sir.
Yes. Good
This is
afternoon,
Dr.
ma'am.
Santosh from the Department of Management Studies, sir.
Yes.
Sir,
Yes.
I just
Please.
wanted to know if we have a design patent, how long does the patent for the design last, sir?
First, I want to clarify one thing that there is no term like design patents in this IPR field. It's a very big misconception between the different university institute people or maybe many learned persons that there is any term like design patent. No, there is no term like design patents. These are two different terms. One is design and one is a patent. So if you are going for a patent filing, it will be for a 20 years. If you are going for a design registration, then it will be for a 10 years in the starting. And after that, if you still believe that it is useful to you, then you can extend it up to 5 more years, means 15 years. So basically in the design registration, you won't get any uh, claim over the technical features of that product or any technology. So I think that would clarify your things.
Yes, sir. Thank you,
Thank you,
sir.
sir. And another question, sir. Can you patent an old design as well?
Yes, please, pardon,
Santosh,
please.
ask once again.
Can we patent an old design also, sir?
Old design in what sense you are asking? Means
Like any existing design which is there, which has not been patented, something
no,
like
no.
which is
Actually,
antique or
no. Actually, first of all, first thing is that you can go for the design registration. For that thing, you can go for the design registration. Patent is a different thing. Patent is for the technical features or for any procedure or for any processes that are related for the production of that, maybe that particular design also. So and if you are talking anything, if there is anything in the system in the prior knowledge, then you cannot go for the design registration for that thing. That product should be novel, or that should be not known to anyone in any written material. It's not like that because
no
someone has not.
identical designs can be done?
Yes, it's not like that someone has not filed for it in the past, then you can get the patent or maybe the design. It's not like that. Because that is in the system, it means that it is already been disclosed. So it's not your knowledge, it's not your intellectual. Basically what you are getting is basically intellectual property rights. So it should be your own intellectual thing. It should not be like you have copied from someone.
Thank you, sir. Thank you, sir, for clearing the doubt.
Before this, I like to show you something just to clarify it in a better way. Is this visible to you all? This some
Sir?
snap. Is this visible? This snap of
Not yet,
one
sir.
bottle that I'm saying. Yes.
No, sir.
Okay. Wait. Now is it visible?
Yes, sir.
Yes. Now, ma'am, some who asked the question earlier.
Yes, yes, she's here. Dr.
Yeah.
Santosh.
Okay. 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 Yes. Now I'm just showing it to everyone, and just to clarify your question also. Can you tell me in how many different IPRs I can file this particular product? Now it's a very. I just want to add some description about this product. It's a glass bottle. Now this glass bottle. I want to file for IPR registration. Now, under how many categories I can file this thing? There are three possibilities.
Three
That
possibilities, sir.
it,
Uh,
yes, it can be filed for a trademark. It's very obvious. Now, I am not interested in trademark, but uh, can I file it for the patents, or can I file it for a design, or can I file it for both the things?
Design, sir.
Design maybe, sir.
Okay. Anybody from the participants, if they believe that
On
if
the
they want
bottle, there
to
is a cover, sir. For that part, we can go for a patent, as it can hold the heat resistant concept will be used in that.
okay, ma'am, can I know who was answering this?
That's a Vaishnavi, sir,
Okay,
from the
okay, okay,
Department
okay,
of
ma'am.
English. Yeah.
Okay, okay, ma'am. Yes, very good. The answer is correct, but I want to add one more thing, that there is one another feature that you can go for the uh, patent registration in that. Just try to identify that also.
Maybe the tag that is used to carry the bottle, sir. The
Yes,
design
that
of
is
the.
okay. That thing we can go for the patent registration, the holding part of the bottle. Yes, because the thing is that any innovations, how we can define the innovation, if anything is solving any prior arts problem, or maybe any problem of the society through any technical means, or through any product. So this particular hanging part is solving one of the problem of holding the bottle. So that is okay, that it's an innovation and it can be filed for a patent. But one another thing is there.
Color?
I'm just asking.
So
The
Yes, yes,
color?
please. No, no, no. That color
maybe
yes,
the
yes.
design of the cap, which allows the heat to be balancing in the bottle.
No, no, no.
The pressure part.
Okay. I'm just asking this question just to clarify one of the things of the patent, that it can be a very simple thing and you might be seeing it on the screen, but you are not aware about it. This center part of the
The
bottle, that
center
is
part.
the gripping, the grip of the bottle.
Grip.
Now understand one thing. Now, in the starting, I have told you one thing, that it's a glass bottle. Now understand the problems of the glass, that if a glass gets wet, it's become very slippery. So to solve the problem of slippage, someone has added this grip in the between of the bottle, the center of the bottle. Now this grip can become an innovation and it can be filed for a patent. So in this way we can identify so many things around us, that how we can add some features maybe, or maybe solve the technologies or some different ways.
Sir, again,
I think
sir, can I,
yes, yes, please.
sir, you are saying that gripping part will be included. In that angle, we can
Yes,
file for patent. Now, again, well,
yes,
if somebody has applied for patent for anti-heat resistant part for the same point, how will we
yes.
differentiate? How they can differentiate?
Actually, yes, you have stated a very nice question, that if someone has said that there is some heat resistant part in the center and which is stopping the flow of heat from one direction to another direction, then also it's a very useful thing, because it is also solving on a second thing, that if it's a glass bottle, maybe any other material bottle, and it's stopping the movement of heat from one direction to other. So it is also useful, and we can go for the patent for this thing also.
But again, one more doubt, sir. Sorry, I'm keep on
Yes,
asking,
yes,
please.
please.
Sir, in US, for disposable cups, this heat resistant point is taken as a patent. Now, again, in India, it is not there. Can I apply for national patent like that?
Which product clarify actually the,
Same thing. Heat resistant part in the middle of the bottle, it is there. No,
okay,
the similar thing is there for disposable cups, for coffee cups.
okay,
In
okay,
US, it is there patent. Can I,
okay.
but in India, it is not followed. Can I take patent in India for the same idea?
Basically, you need to understand that in the in between the webinar, the presentation, I have told you that it's a sovereign right or state right. So there are certain things that are being patentable in India and that are not being patentable in US. Means some people in the means the system in the US may allow you to get the patent, but in India you may not get the patent for the same thing. So there are chances like that. So I cannot say that you can get the patent or you cannot get the patent. It's depend upon the person who is looking after your applications. Means let us assume that I was checking and looking after your application, then it's my discretion at some point of time that I will say that it is patentable thing, and at some point of time I may think that it may not be a patentable thing. So it's a thing of discretion at some point of time, because it's us who are actually looking after the things, that whether it's patentable or not.
So one last question, sir.
And one other thing, just one another thing is that it also depend upon the applicant and the inventor also, that how important that patent is for them also, because sometimes what happens that we send them a report for the patent, that we send them a FER, first examination reports, and then how you reply your report is very much important, because you need to justify the thing, that let us assume that I have said that these XYZ, these documents 1, 2, 3 is disclosing your technology. But now it's your duty to explain to us that this particular technology is very much different from the thing that you have cited, because the actual essence of the invention is clear to you only, who is actually the inventor. So you need to define to us in the report that these are the features that I am asking for, or these are the additions, or these are the things that I have added. That thing also you need to be clarify. So in sometimes what happens that someone is filed for a patent and they are not much interested. They thought that yes, if I got the patent, it's okay. If it's not granted, then also okay. So they don't. They are not much focused about drafting things, reports and other things, the replies and other things. So that also matters in these cases. Yes, Vaishnavi, you can ask whatever you want.
Yeah. Last question, sir. If I have an idea related to an app, like I want to create an app, uh, Do I need to go for IPR or copyright, sir?
It's also, I would say, it's a very good question because I believe that you are working a lot in this particular IPR field. That's why you know these things. I'm glad that you understood this topic so well. Talking about the apps and these things, it's again a thing of discretion because basically we don't give patents for the applications or maybe the algorithms or these things. For these things you can get the copyrights, but for getting the patents you need to justify the answer that that particular app is solving some human problem in a means if you are solving some human problem in a physical way, then there are chances. I cannot assure you that you will get the patent, but there are chances that you can get the patent. First thing is that. Second thing is that if you are developing any product and you are using that application in that product, let us assume that you have uh, developed any app which is used for the food delivery thing, or maybe which connects with the different restaurants around you. So if you ask for that application, that there are chances that you may not get the patent because we will say that it's under the section 3K or section another other section, that this is just an algorithm. But let us assume that I have developed some device, any hardware device, and if I say that this particular device I am using for the for this particular purpose only, means for the ordering of the food only, and I am using this all algorithm or application in this particular device. So for the device and algorithm all together you can get the patent. That is very much, that is okay, that you will definitely get the patent if you are connecting your, if you are using any application in that particular device.
Thank you, sir. Thank you very much.
Okay. One another question I will would like to ask you all, that can you explain me why this is written in this part of this, it's a snap from YouTube, it's a video, so I have taken it. So why this is written on this, that audio in this section has been muted to avoid the copyright infringement? Can anybody from the participant explain me this thing?
Maybe the music used was already taken as a music, or the dialogue that is used in this particular scene might have already been part of a copyright. Like, for example, they might have taken from a movie, the song was taken or the music was taken, something like that, sir.
Okay. Let us. I just want to ask you one thing, that if like Sony Pal is a very popular channel, so they would have taken the permission from the proprietor to play the video on the different on the direct to home services, like on the like we have Tata Sky, we have Airtel TV, or maybe Reliance TV. So on that particular platform, they have played this particular section, but why they have muted this section on the YouTube? It's a snap from the YouTube.
So might be they didn't take the permission from the Sony. That's the reason why.
No, that's being published by the Sony Pal only.
Sir, when we are uploading in the YouTube, we have to. It is asking about the. We have to take the permission from the person where we are using that audio or video. For that reason,
Okay. Yes, ma'am. Basically what happens, I just want to clarify this thing because there are so many questions about the copyright and infringement related things, so that's why I've asked this particular question. One thing about the copyright is that whenever there is an infringement, it only happens because of the economical gain is related to it. Means if I am let us assume that I am listening the songs, or maybe I am listening the songs in my home, or maybe on we play the songs in our shadis or maybe any other different platform. So there is no copyright infringement. The reason is that because we are not earning any out of, we are not commercializing the things. But the same thing, if we see the same thing, like if the radio channels play these songs, or if any other app like we have Ghana or maybe Savan or maybe uh, any other app, then what they have to do they have to take the permission from the proprietor, because they are getting the economical benefits out of it. So if there is any economy related to it, if there is any monetary benefit related to it, then there is copyright infringement. If there is no uh, economical benefit, then there is no copyright infringement. Earlier there was a case that happened in 2008 and 2009 when one of the movie song was played in a cricket stadium. So in the cricket stadium, they played that song, and the proprietor has filed the case against the stadium authorities that they have played their song in the stadium without taking the permission. And after that, they have to pay the royalty to the proprietor. The reason is that because the authorities are asking for a money to people from the people to see the matches and to see the things. So they are getting the economical benefit. So that is the reason. Now talking about this particular case, this YouTube Snap. Now the Sony Pal may have taken the permission from the proprietor to play the video on the direct to home services, mean Tata Sky or any other mode. But YouTube is also a way to monetize the things. So if you are playing the video on YouTube, then also you have to take the permission from the proprietor again, because you are getting the money from the YouTube. So that is the reason they have uh, done this thing. They have muted this part. So I think that would be clear to you all. If you have any other questions, we can take it. Else, we will end the session here.
Thank you, sir. As NIPM is aiming to spread this awareness on intellectual property so that there will be a conducive environment of innovation and creativity, we too will thrive our best to create the same environment in the college, sir. And thank you so much for the wonderful session. We are so much
Thank you, ma'am. Thank you,
enlightened
ma'am.
by your sessions. Thank you so much for your cooperation, sir. As soon as we asked, you
Thank you.
readily came forward. We are very fortunate to have you, sir. Thank you so much.
Thank you, ma'am.
And I would like
Just
to,
in the
sir,
end, I would like to add on that there may be people who are not from the science background or maybe technical field that you have
yes, sir.
already stated in the starting. But I just want to say that there is no requirement for any technical or any other field in the patent filing or any other IPR filing. The reason is that because innovation, or maybe we can what we can say, intellectuality doesn't come from any field. It can be an educated person or it can be any uneducated person. It doesn't mean that you need to have some qualification or some things like that. You see so many innovative ideas that are being developed by so many villagers or so many people from our past, you have seen in the past. So you just need to identify the problems that we are having in our society, or maybe we are having in our field. I have seen so many patents being filed by the doctors itself. Now, the what type of patents they file? Now, the patents they file are usually the different instruments or different devices that are being dealt by them. Means they are using these devices for their purposes. So they identify the problems of their working culture, that these type of problems that we are facing in our devices or maybe in our technology. So they suggest these things. So what you can do from your part, that if you belong to any other field, then what environment you are working, what are the problems that you can solve through the different devices or different technology or maybe products. You can give those ideas and you can work on it, and you can uh, become a good entrepreneur or start your own business on these ideas.
Okay, thank you, sir. So just I would like to invite Vaishnavi ma'am to propose vote of thanks. Sir.
I thank Almighty for giving this opportunity in organizing this workshop on intellectual property rights and IP management for startup under the leadership of our principal and IIC president of St. Teresa's, Dr.Sr. Mercy. I thank my gratitude to our resource person, Mr. Shailendra Garu, to take out time from his busy schedule to ignite our participants. Thank you, sir. I vouch on behalf of our participants that the information shared by you made it crystal clear to know more about patents, trademarks, geographical identifications, copyrights, etc., sir. Thank you very much, sir. It's a pleasure to extend my gratitude to the convener, Dr. Padmaja, and ISC committee for organizing one-stop clarity for IPR related queries. I thank tech support for helping in concluding the webinar without any technical glitch. Finally, I thank all the students, faculty and professionals for their active participation. Looking forward to such kind of knowledge extension programs. Thank you all.
Sister, would you like to add something, sister?
Sir, so it was really very, very inspiring and very, very useful for all of us because
Thank you, ma'am. Thank you, ma'am.
we are a college which is really looking forward to improve the innovation practices in the campus, and therefore is really very, very useful. Thank you so much, sir.
Thank you, ma'am. Thank you.
Thank you, sir. Thank you so much, sir.
Thank you, ma'am.
Sir.
Thank you.
Okay, sir. Thank you, sir.